much. We're on the record in case 831. Okay, everybody ready? 831543, Hunwardsen versus Affinity Lifestyles, DBA Real Water, and ETT DBA Terrible Herbst. So, councils, did you want to make appearances today, or just say same councils, same parties? The court's fine either this way.
Can you actually have them do it?
Oh.
The transcribers are asking me to.
So transcribers are asking that we ask you to do appearances. So would you mind, councils for plaintiffs, to please make your appearance?
Of course. Good morning, Your Honor. Good morning, everyone. Teddy Parker, Joul, and Eric Pepperman on behalf of plaintiffs.
Good morning, Your Honor. Joel Odou, Mark Love, Sheriff Freeman, and Matt Kaufman on behalf of the Real Water defendants.
Good morning, Your Honor. Valerie Rojas, John Thomas Sig, Dan Boho, and Dan Waite on behalf of defendant ETT.
Okay. Do I need to check remotely for anyone, or is everyone taking care of appearances?
Oh, as well as Abe Smith is appearing via remote.
Okay. Well, I just want to make sure everyone's taken care of. Okay. So we have motion practice first thing this morning before trial. So the question the court has to ask y'all two questions. One question that was asked of the court is, pursuant to the media request, our Nevada judges had a media request for all motion hearings, including trial, okay? So they're able to do anything other than what's not permissible under the rules, such as juries, breaks, etc. With regards to Court View Network, and if I'm mispronouncing your name, I'm pretty close, had asked only for being able to record from opening statements on. They're here present in the courtroom. You may have heard right before we went on the record, they had requested whether or not they could start with this morning's motion hearing, since that's not part of their media request. The court needs to just ask the parties your position. And they're of course not recording anything while I'm asking you, because that would be appropriate, right? Go ahead.
Your Honor, plaintiffs have no objection.
Your Honor, Joel Odou for Real Water, we have no objection.
Valerie Rojas for ETT, we have no objection on.
Okay, there being no objection, it's up to you. You just remember same rules with, can't do during breaks, because as you can appreciate, councils and things may be talking about things, other matters, and other aspects like that. Okay, so, visual aids are, okay. I was told to mention that plaintiff's visual aids are in the hallway.
Yes, sure. We are back.
Okay, Marshall, somebody told Marshall to please tell me to tell you, so no worries, it's taken care of. And counsels for defense, I didn't see any messages on your behalf, otherwise I would have relayed them as well. So, what we're doing at this juncture is we are first addressing the conclusion. As you all know, you had an opportunity to fully argue the motion to strike, a renewed motion to strike on the other day. Then you had an evidentiary, almost all day evidentiary hearing on said motion to strike, which you then were able to also present whatever witnesses you chose to do so and engage in some kind of closing statements / argument in that regard as well. So what the court did is the court gave from the bench its oral ruling in part. I gave pretty much what I would say the ruling as far as that the court finds that sanctions are appropriate. I was going to just mention a couple other things that just from time standpoint yesterday didn't get fully addressed. When we talked about the coordinated matters, as you all probably know, every one of your pleadings specifically say that they're coordinated for discovery purposes in all the cases that are coordinated. So it's clearly on notice for everyone that there is a coordination aspect. The court went into some of the testimony of some of the witnesses in my analysis yesterday, and so I probably should mention a couple of the other witnesses as well, because it was part of the court's determination. We were listening to Mr. Breeden. One of the concerns with regards to Mr. Breeden's testimony is he would have had an affirmative obligation under the rules to do a full and diligent search. As he stated during his testimony, he only looked at his inbox. He didn't say he looked at even his sent box. So that's one of the things that the court had to consider as well. When I looked at the scope of what Mr. Walter said, is he really didn't even indicate what he had looked at and when he looked at it. But you did have the fact that they were stated, some of the witnesses stated that they were not even asked to even look at their respective, whether it be a Dropbox or anything else, until a time period in 2023. Whereas there was obligations in 2021, 2022 with regards to the interrogatories, because those were referenced in the declarations, as well as prior to in 2023. The court has no information that's been provided that, as far as any diligence or anything that was done to comply with the affirmative obligation to maintain records, which is an inherent obligation and is not something that needs to be presented by the parties. And so the court didn't have any benefit of that information. There was a general reference with regards to Mr. Kempfer's testimony as to some requests that he made prior to his signing the interrogatories, but when I listened to what that was, the court we found that that would have met the appropriate basis of what would be required in order to do the interrogatories. So at this juncture, I'm just mentioning there were some other facts that was in the court's ruling, which due to the time frame, yesterday did not have an opportunity to articulate, so I was articulating today. The court still comes to the same conclusion that the closest analysis you have for the definition of willfulness comes in the destruction context. It was cited in MDB tracking that was in the U.S. papers. While that is a destruction case and this is a failure to disclose case, realistically, the harm asserted is very, very similar because of the timing issue. By not presenting any documents until after the commencement of the, whether it be the day before because it was a holiday or the day of the beginning of jury selection has a very large impact. With regards to the witness issue that was raised, the court has to take into account because said documents, at least the ones presented to the court through the evidentiary hearing, including but not limited to, you all referenced 2406, 2407, 2384, 2387, 2352, 2353, and 2357. At least some of those, most of those included names of other individuals that are not on the witness list. So the court does have to address, because the issue of striking came with regards to the emails and the lack of those being presented, those emails, since they also identified individuals that were not on the disclosed witness list. The court does need to take that into account and does not find that that issue would have been waived, because you have to look at the underlying documents. If you don't have the underlying documents, you don't have the information on who potential witnesses are unless they were independently named as individual witnesses, which they're not in most cases. And the court's, of course, not saying that you already went through Mr. Breeden when he got disclosed, and obviously Mr. Kemper was disclosed. I'm talking about there are at least additional names therein. And additional references to other potential exhibits and documents. So looking at the totality of all that, the court did find that there is sanctionable conduct, and the court has to look at, for this unique particular procedural posture of this case, is what is the appropriate sanction remedy. The court already went through yesterday, and if you want a citation, I mean, I could give you, I already referenced with regards to NRS 42.005, punitive damages standard, with regards to what's necessary for the clear and convincing standard. And if you want a case law, it goes back for a long time. For those of you who know Clark versus Lubritz, which involved a series of various medical professionals in the community at the time. So, and its progeny as to what is really considered for purposes of punitive damages and where it can come in. So in light of that, the court found that it couldn't make an affirmative determination that punitive damages are awardable, because there's no case law that says that there could be a sanction for the type of conduct at issue in the motion to strike that somehow would allow, when there is a heightened evidentiary burden, i.e. clear and convincing under punitive damages, for the court as a sanction to say an evidentiary standard, heightened evidentiary standard is met, particularly when you look at the purpose of punitive damages. And I mentioned Clark versus Lubritz and its progeny, and there's a whole plethora of cases in a whole bunch of different contexts, but they always go through what the purpose is, and the purpose is with regards to the underlying conduct of the parties with respect to the claims at issue. They don't address it being a sanction component type issue. So the court really was allowing the parties an opportunity to A, see if you came to an agreement with regards to what should be the sanction, and B, if not, that you basically get a minute or two, and it's a literal minute or two under 60 seconds minutes, not lawyer minutes, to provide the court what you think the remedy should be on each side. In no way, when the defendant provides their basis, waiving their right to say that there shouldn't have been any kind of remedy. It's just the court's already made a ruling it's going to do something, so it's a matter of giving an opportunity to say what is the something that should be done. With that being said, that means, Counselor Plaintiff, I am going to ask you if you want to go first or second, because realistically,
That's a good question.
I'm gonna go second, John.
okay.
Let's
The
let
court's
Mr. Waite
gonna
go
allow-
first.
the
I've been
court's gonna
going
allow
first all
that.
week. and all last week.
Thank you, my friend.
Anytime, Dan.
Okay, so that means, Mr. Waite, you're coming to the podium. Go ahead, please, on behalf of ET&T.
Okay, thank you, Your Honor, Dan Waite, and I really appreciate your comment, and I fully expected that this court would not be offended by a comment if I made that we don't agree with the ruling and we preserve our appeal rights. But in trying to comply with this court's order and direction to make some suggestions of sanctions that are severe, I think is the word to use.
Okay, now let me be clear. I'm not requiring you to do so. I'm giving you the opportunity to present the court something that you may feel is appropriate. You may just say, no, Your Honor, we want you to decide all on your own and we don't want to provide it. I think the fair and equitable thing is to give each side an opportunity to provide what they think they want to.
Okay.
I'm not requiring you to decide so the court can come up with its own analysis.
I appreciate that, but I must respond to the addition of the word, what we think is appropriate, because I must preserve the record that we don't think a sanction is appropriate. But setting that aside, Your Honor, we had significant discussions after court yesterday, including beyond 10 o'clock last night and on my way into court this morning and even out in the hallway. So what I am authorized to present is 3 different suggestions, Your Honor. And the first one has kind of a part B that maybe is an alternative in itself. 2 of those are forms of monetary sanctions, and the last one that I'll present is a form of an evidentiary sanction. And to be clear, I'm not suggesting the court award all 3 of these. I'm suggesting these as suggestions of the court select one of them because we consider all of them to be severe sanctions. The first one is kind of a follow-up to what you proposed yesterday, and that is one option would be at totally our cost to vacate the current trial, release the jury, allow the plaintiffs to conduct the discovery that they suggested they would have conducted had the information been disclosed sooner, and again, to assess the costs against us. The variety of that is, if that is too imposing on the jury and other types of things.
Can I pause you for a second?
Sure.
So I need to get a clarification. You understand you would lose this jury, right? You would not get these same panel members at all, and realistically, that impacts on whether or not you could even get major questionnaires, et cetera, in the months-long time period in that. And you understand many of the parties are set for another trial in another department. I just need to know, when you say jury, you say you're suggesting the same jury? Or you say?
No. I thought I indicated release this jury.
Okay.
And I understand and appreciate that that involves a tremendous amount of expense and so forth, and that's why there's a variation of that proposal. Still, in option 1 would be to keep this jury, but to find a few dark days that we can cobble together, and during those dark days, allow plaintiffs to conduct the discovery at our expense, and then proceed. Option 2, Your Honor, a fixed monetary sanction that just, is a punishment, if you will, to ET&T for its conduct. Something that we feel would be severe. Obviously, you would award under this option whatever you felt was appropriate, but in the neighborhood of $100,000 sanction, a $25,000 sanction to the $100,000 going to plaintiffs, $25,000 to some laudable charity like Legal Aid, this Center of Southern Nevada, or Safe Nest, or something along those lines. But that's pretty simple and straightforward, with the issue being the amount. The third option, Your Honor, evidentiary in nature, would come in the form of an instruction to the jury. The plaintiffs have claimed, and trying to relate the conduct to the claimed prejudice. We don't necessarily agree, of course, that the claimed prejudice actually exists, but trying to link the conduct to the claimed prejudice. Plaintiffs have claimed, and I believe they have shared slides that show that their punitive damages are based on certain conduct by ETT. And so an instruction, something along the lines as follows, that the jury would be instructed that the jury will accept the following as established facts in this case. And turning to those facts, one, that ETT marketed real water with coupons and pump ads. Two, ETT sold approximately 200,000 bottles of real water in 2019 and in 2020. Three, ETT did not require third-party audits of real water. And four, ETT did not request third-party audits of real water. So these are the things that they have identified. These items are included with what they have identified as what they're going to base their claims for punitive damages against ETT. And the jury could accept those as established facts in this case. Again, we are not stipulating to them, but the court could instruct them as a sanction. Trying to be as brief as possible. Your
No,
Honor.
I appreciate it. I'm just getting for a point of clarification,
Sure.
and once again, you don't need to answer this question, but the court's just asking for a point of clarification. Are the four facts that you just stated, are they disputed?
I believe, for example, in the first one, the extent of which the marketing occurred, and that may be something that the court considers. I think that they have, for example, indicated that, I can't remember if the word is heavily or extensively or something like that, which is greatly disputed. As far as the other points, Your Honor, the number of bottles sold, so forth, no, I can't sit here and say that those are.
So how is it a sanction? I
Yeah.
have to ask you that question, counsel, because if they're already undisputed facts and they're coming in anyway, I have to ask you how, I mean, I appreciate the time that you all took to come up with this, but how is that a sanction?
Yeah, well, that's our suggestion, Your Honor. They can certainly suggest modifications to those. Certainly as it relates to facts that we do contest, like how heavily or extensively we marketed the project, we would greatly dispute that, and Your Honor could issue a sanction and say, notwithstanding, this is the sanction. Yes. Counsel reminds me, for example, about the videos on the pump.
Court's already ruled on that, though. That's, please see the court's prior ruling, right?
That they actually occurred,
Yes.
they were produced.
It's page 7 of the court's prior ruling dated January 17, 2024 from the December hearing. Is that the one you're referencing, the BMX one?
You know, I could show it to them, I brought it.
I've read that order, Your Honor. I don't recall that specifically, but I know I've read that order.
No worries,
No, that's fine.
no worries.
Your Honor, I don't know that I have any other or additional response to that last component, other than that we're operating an evidentiary sanction, and the final wrinkles and ramifications of that can still be determined, but we throw it as a suggestion. Their claim of prejudice was related to their punitive damage claim, and these were the things that on their slide they were going to rely upon, and that's the suggestion, Your Honor.
Okay. Thank you. Here's what I'm going to do, and I'm going to check with everyone to make sure it's okay. Since one of the requested alternatives by ETT would impact real water, I'm going to ask them if they have a position. Does anyone object to that?
No. No objection, Your Honor.
Okay.
Your Honor, before Mr. Odou speaks, I just wanted to know if the court was aware of the most recent Nevada Supreme Court case on this subject, the Blige versus Terry, December 28, 2023. You're aware of that? Okay, perfect.
Yeah, all right, okay. So, real water, the only reason why I'm asking you is because one of those impacts the trial overall. You're a party to this trial, so if you wish to express an opinion, you can on that potentiality, and if it impacts real water. If you don't, you're not required to.
Thank you, Your Honor. Joel Odou for Real Water. I do wish to address that issue, Your Honor, and I'm going to address it globally. Real Water has no position in terms of the argument as to should ET have been sanctioned. That argument is now concluded. Now the question is the remedy for that sanction. And Real Water's concern is that that remedy not prejudice Real Water. In particular, the issue, it appears to us, is the veracity of some of the statements were provided to the court. And if there's going to be an inference or some type of finding that people were untruthful, or that the jury is informed that people were untruthful, that is very problematic for real water, Your Honor. If the sanction is of such a severe nature that it prejudices real water's ability to defend this case, such as some type of finding that evidence was willfully or negligently even lost, misplaced, or withheld, or somehow plaintiffs were not permitted to have this evidence intentionally. I think the court knows where I'm going with this, is if the sanction is of such a severe nature, then real water would be prejudiced. And the only way to alleviate that prejudice, in our view, would be to either sever us or bifurcate it or some other remedy, and we don't want to do that, Your Honor. And so we don't want a sanction that is so severe that we're left with no other choice but to ask this court to sever us out of this case, because we've already picked a jury. But even a curative instruction, such as that was another party, that was not real water, is still very problematic to us, Your Honor.
Counsel, can you appreciate, the court did ask a specific question, right? Remember ETT said that one of them was to, quote, start over with a new jury. That's why I was saying because remember, real water specifically stated that it did not have a position on the pending motion. And the motion would include both the determination and the remedy of the motion, because you had an opportunity to file whatever briefing you wanted to, even if it was specifically addressing the remedy portion, you chose not to. The reason why the court was allowing real water, if they wanted to express something, is because the court wouldn't have known until this morning what ETT was suggesting, since they suggested one potential remedy was to start over with a new jury, since that would impact real water. I need to know if you had a position on that.
That would impact real water, and I don't see how we can do that. The parties have spent a great deal of time and money getting this jury thing handled, and I don't know how we can do that, Your Honor. And again, this is our first opportunity to hear their position on the sanctions. In a few moments, we're going to hear plaintiff's position on the sanctions that could impact us.
But counsel, you understand that's not specifically correct, because in
It is
the
not.
pleadings, plaintiffs proposed potential sanctions in the motion, by its very definition, said motion to strike rather than alternative relief with regards to punitive damage calculation.
That's right, and that would affect us because there are two findings of punitive damages in the proposed verdict. If something is going to change and the verdict is going to be different, or there's some remedy that's going to be new that affects us, then that's where we would have a problem.
Where the court was going to finish its sentence was, and then in the opposition, counsel for ETT set forth what it was appropriate lesser sanctions, which, while not exactly the same as stated this morning, similar type issues were raised in their opposition. And so where this court's viewpoint would be is, when you see a motion to strike, which is asking for a variety of different things, and given the case law, right, which includes lesser sanctions, being here for the court's prior ruling with regards to the December 20th hearing that's memorialized in the order of 117, which your client also signed off on, only it's approved as content and form, appreciate you having a position on it, is that realistically, if you had a limited opposition, it could have been filed. With regards to both the substantive aspect as well as the remedy aspect. Today was realistically because the court was already saying it was not going to strike, and so I'm evaluating the lesser sanctions that were in the pleadings and other lesser sanctions that were subsumed within the motion practice. So I'm hearing what you're saying, I'm not taking a position on what you're saying, but I'm just explaining why the court was asking you the specific question with regards to the talk when I'm
Sorry, Your Honor.
That's why the court asked a specific question with regards to the new jury, because that was not in the pleadings, and in fairness, you would have an opportunity to speak on that. Thank you very much. We're now going to Plaintiffs' Counsel.
Thank you, Your Honor.
Plaintiffs' Counsel. Your position, please.
Yes, Your Honor. Good morning, Daniel. I wanted to say thank you for the homework assignment last night. I spent some time
It was an optional, it was not required, it was only giving everyone an opportunity.
Your Honor, I enjoy the homework sometimes. And quite often when I'm in this courtroom, you give me things to ponder, and last night you gave me something that lasted beyond my run period. So I was on and off the treadmill still thinking about the homework assignment. But, Your Honor, one thing I was able to determine, but for the Blige versus Terry case, under Young versus Ribeiro and his progeny, there is no other case that addressed punitive damages, and you were correct when you went through the analysis yesterday. The only thing that struck me was that under Young versus Johnny Ribeiro, there is no factor number 9. And so factor number 9 would be potentially the punitive damage issue. It could be the size of the case, the value of the case. There's no, that's not one of the court's considerations under Young Ribeiro. And then I looked under Rule 37, and Rule 37 does not have that as a consideration, the size of the case, the types of damages being sought. So under Rule 37 and under Young Ribeiro and his progeny, the considerations that the court was really concerned about yesterday are not factors that the court has to consider given the Nevada Supreme Court's decisions under Rule 37. And then that Blige-Terry case was the first time, which was December 28th of last year, that a Nevada Supreme Court decision actually reflected a default being entered involving punitive damage. And so I truly appreciated the comments because your analysis was actually deeper than I think presented by myself as well as that presented by ETT. And so I meaningfully say I appreciate the homework assignment. The only other thing I would
But
say.
to understand Blige, and I'm stopping for a quick second, because Blige was setting aside a default, right, with a pro se party.
Understood.
Okay, go
I
ahead.
understand. I'm just saying the considerations there.
Okay.
And so, and then a part of my thought, given what the Young factors are, which didn't include the size of the case or the damage being sought in Rule 37, was if you use that to be a factor, the size of the case and the damage being sought, then a case like Nevada Power
I
for.
think you may have misunderstood what the court was utilizing that. What it was saying is, here's what you have in this case. You made a request to strike their affirmative defenses, right? To
Yes.
strike their answer, to strike their affirmative defenses.
Yes, Judge.
Looking at the procedural aspect of where this case is, what actually affirmative defenses are left? Their only affirmative defenses go to basically punitive damages because there's a potentially, I'm not gonna say there's a presumed dollar because that's gonna take long, but okay. Doesn't seem like anyone's saying that there's not a dollar with regards to
Compensatory?
compensatory damages with possibly a carve out with one plaintiff because your stipulation is a little bit different.
You think about Brody?
Yes,
Okay, I think the stipulation is the same now for Brody. So we're on the same page with that one as well.
okay. But, so.
Originally it started out with just liability, now it's liability and.
Right, no, I appreciate it, but you all have phrased those as the amount of damages. Nobody has clarified to this court, when you use the term amount of damages, does that presume it's a proverbial penny or something greater, or whether that means they can still argue a zero? So that's the reason why the court was pausing in that regard, okay?
That's been established by the summary judgment on the medical bills.
I was going to go there.
Oh, I'm sorry.
next,
I'm
but your
on top of
medical-
my game today, you know.
No. But your
Right.
medical- and that's where I get the carve out with Brody, right? Because the medical bill aspect with Brody was decided prior. Your medical bill issue, and the court would have to go back and double check, but from the court's understanding is there was not a concession on medical bills for Brody that at least had some dollar amount because of the timing of when you had the stipulation. Now, once again, that was gonna be a point of clarification for the court to ask the parties. So what this court was taking into account is what affirmative defenses actually exist in the answer that could be stricken, right? So if you take the fact that you at least have an agreement through your stipulations that there's, I'm saying a penny, a dollar, obviously it's something more, but okay,
Absolutely.
that if you look at that, then realistically, you can't get to a specific number for damages under striking an affirmative defense because there is no affirmative defense that says it's X, not Y. okay? You have a certain contention because you have outstanding issues with regards to pain and suffering and other components, right? And depending on which plaintiff it is, shortness of life, Mr. Hunwardsen, et cetera. And remember, for ETT, this only applies to Mr. Hunwardsen because he's the only plaintiff that is asserted, at least so far, I haven't seen any amended complaint in the middle of trial, okay, but at least asserted in this case that purchased from ETT. So I have to focus on Mr. Hunwardsen, right? Mr. Hunwardsen's issues. There is a number that's out there for compensatory damages for the jury to decide. That's not an affirmative defense. The other issues with regards to Mr. Hunwardsen only, right, is whether or not you can presume that there's punitive damages. And that affirmative defense is with regards to the conduct and the nature, okay? In a broad sense, there are affirmative defenses, right? Because they also have the caveat language. Is there something that says that a court can strike those affirmative defenses because the nature of punitive damages has an evidentiary-based aspect that is tied to the actions at the time of the underlying issues, not for whether you call it discovery misconduct or other sanctionables, or you can even say pre-discovery, because if you recall, MDB trucking even went to pre-litigation conduct, and they talked about 37, and in pre-litigation they talked about other aspects and sources of inherent sanctions. Court couldn't find anything. And yes, familiar with Blige, but Blige was whether or not it was proper to set aside the default, right? It wasn't to issue. Now the default had certain components, but remember procedurally that's different. And you had a pro se litigant who realistically, on a credibility standpoint, they said they didn't necessarily agree that that pro se litigant was or was not aware of discovery. So when you look at those factors, that's where the court was going. The court wasn't saying because this is a large case that the court should do a different evidentiary burden. The court was saying I have to look at the specific facts of this case, the specific procedural posture of this case. As of the time, you all had me do the evidentiary hearing, because by agreement, you had me do this motion first before the motion for summary judgment.
That's correct.
Okay, so whether you all are gonna tell me you don't wanna actually hear my ruling, you want me to rule on the renewed, rehearing on the motion for summary judgment, who knows? I haven't heard it yet, I don't know. I have to take the procedural posture as it is. So I'm hearing what you're saying, but it's nuanced different than what the court was really relying on. So I just wanted to get that point of clarification.
No, I appreciate that.
So I was not adding a ninth factor, but do remember John Rivero does say, they all say, right, it's not an exhaustive list, these are things the court should consider, and all of them give the court the discretion to consider the facts of a particular case, because as you can appreciate, from a timing standpoint, different facts, different cases, and the Supreme Court has really consistently allowed the courts to add, even if they give it a laundry list, whether it be a Foster Dingwall list, whether it be a Foster, eye experts, whether it's Brunzell, whatever the thing is, also includes court discretion to evaluate other factors that they deem appropriate. So, long-winded way of saying my nuanced analysis was a little bit different, but go ahead, please.
And I'll be thinking about that on the treadmill tonight, And I appreciate, like I
At least
said,
you're having time for the treadmill, counsel, go ahead.
some of my best thinking there, Your Honor. Your Honor, the only other point, and I like what you just said in terms of applying the sanction to where we are procedurally and considering where we are in this case substantively. And I think you're right. The closest thing we could come to would be the CCSD case, because that would involve the striking of the affirmative defenses.
But you didn't have in that case, are you gonna say that the only issue was compensatory and punitive damages in CCSD before the striking? It was procedurally different, right?
In that case, there was a contract claim, there was a breach of covenant of good faith and fair dealing claim, and there were some other claims that were negligence claim based that really didn't work. But the breach of contract claim was awarded. The breach of the covenant of good faith and fair dealing was also awarded in that case. And so, of course, because Judge Levitt in that case struck all the affirmative defenses, struck all of the experts for the defendant in that case. And if you recall, what happened in that case was there were 2 false affidavits submitted related to the production of documents. And they used those false affidavits to prevent the plaintiff from being able to bring their own experts in and make certain claims. During the examination of Mr. McPartland, who was the CCSD head of our facilities, he said, counsel told me I did not have to produce these additional documents because he had already produced them for us. And then it came to light during that testimony that he had roughly 1,500 pages of documents that were never produced. Also identifying witnesses as well. And so as a result, we had a week evidentiary hearing. The jury was released and then allowed to come back after that week. The plaintiff had a chance to review all the documents, and eventually the court said, you hid the documents, you hid, names of people within those documents. As a result, we're striking all your affirmative defenses and we're striking all your witnesses. And that's what happened in that case, which was about a week or so into trial. So here, ET&T has affirmative defenses, they have witnesses, and we're trying to fashion something short of striking. And the problem that case has is because the Supreme Court actually affirmed all of the sanctions and said that the judge unfortunately conflated some of the affirmative defenses with the plaintiff having proved a prima facie case. Now,
Okay, go ahead.
In
Once
the
you finish,
blinds-
that's why I'm asking you, is because it's the prima facie
that's
case
it.
issue.
And now, Your Honor, like I said, I had a great run. I appreciate the homework assignment. The Blige-Terry case talks again about the prima facie case being proven on the Bitcoin matter. Now, when you compare and analogize the situation we're in here, given the facts of the CCSD case and the plain reading of Rule 37 and Young versus Riviero, and I will tell you in all candor, I called Mr. Odou this morning at 7 o'clock because some of the things he mentioned I was concerned about, and because I don't want this to be, I don't want to create error if we can avoid it. And that's why I think the court spends so much time analyzing all of these cases, because it's a lot. And when you look at 37, it doesn't give you any real direction on this nuanced issue. It simply says, it doesn't distinguish or provide an exception or exception for punitive damages or other considerations of heightened burdens. So I think it applies to all cases regardless of the type of sanctions being sought or the affirmative defenses being alleged. So under 37, I think the sanctions, and this again just goes to sanctions, we can't, it's hard for us to suggest a sanction that may unfairly target real water, given what happened in Gallagher, which we know what happened there. So I think striking based upon the case law and the rule is the only way of not, in my opinion, compromising or harming in any way real water's position. Because real water also did not have the documents. Real water also didn't have the list, or could prepare its case. And so that's one thing I'm concerned about. But this is a distant second, and I don't think it's consistent with the rule, because I think that the court took a second and considered Rule 37C and based upon not having an exemption or exception to even a heightened standard for punitive damages, or looking at CCSD using the breach of the covenant of good faith and fair dealing, because that is a heightened standard. So it's probably tantamount, in my opinion, to the burden for, you got to show some type of intent or fraudulent conduct, typically to get to that level, because unfortunately in that case, the Supreme Court said we're going to limit the amount because they thought it was an intentional tort on the breach of covenant of good faith and fair dealing against a political subdivision of the state. That's a little more
Right, you have
nuanced.
nuance whether or not they waive it 50 days.
Exactly, that's right. So, Your Honor, I would ask that the court give that some consideration, but I did bring a list of sanctions that I think Mr. Waite must not have really reviewed it recently, maybe he reviewed it in the past, but the court's prior order is
Tom,
correct.
please, I mean, you gotta be fair. A lot of attorneys are coming in a lot of different cases, and your familiarity of dealing with these multitude of cases, you know what I mean? You
Like I
all
said,
do have the benefit of being in all these cases pretty much since day one. And I say all these cases, at least having a plaintiff in all of them. People coming into cases, do diligent jobs, and you know what I mean?
Oh, Mr. Waite does a very diligent job. I'm saying he may have reviewed it and not remember the particular some of the particular findings. It's a long order.
That's why I have it in front of me.
It's 8 pages long, so anybody can miss some of the information in the actual order. But what Mr. Waite suggested is already contained in the order, Your Honor. And then what Mr. Waite suggested in terms of the amount of bottles sold, that's already been a part of the answers to written discovery. It's part of the deposition, that's already admitted in the case. In terms of the audits, we know that, that's admitted as a part of the written discovery as well as the depositions. Everything he suggested has already been determined in this case, despite this sanction. So, Your Honor, what we would suggest, and this is a very distant second, I don't believe it's a by any means reduces or eliminates the prejudice to plaintiffs, but this is what we suggest, Your Honor. Terrible Herbst be precluded from offering any arguments or evidence. And I brought a copy of it, Your Honor, if you want me to just give it to you. It may be
Do you have a
easier.
copy for your TT as well?
I do. Now, don't find me following it just because it's not completely.
Sure. And Mike,
Well, here
I
is-
can have somebody make an extra copy if you only have.
No, I have another one.
Okay, no worries.
Want me to get the real water?
You want to do a copy?
No, thank you.
Okay,
You want me to approach that?
yes. Thank you.
You're welcome. I thought this would be easier, Your Honor. What it does not take into consideration, Your Honor, because of the comments yesterday and some new things came up today that I think we should add to it, but the first one deals with Terrible Herbst is precluded from offering any arguments or evidence regarding compensatory damages at trial. This would include prohibiting Terrible Herbst from offering arguments or references regarding compensatory damages during opening or closing statements, including but not limited to disputing the nature or extent of plaintiff's injuries or damages, either in category or amount. Terrible Herbst is not precluded from arguing against liability for punitive damages. That was the concern I have given the CCSD in a more recent case. That's something we can discuss. Number two, Terrible Herbst cannot question any compensatory damages witnesses, including not limited to Myles Hunwardsen, Dr. Hudson, Steve Uhas, Dr. Alcina, Matt Sims, or Melissa Kennington. Number three, Terrible Herbst cannot present its own witnesses regarding compensatory damages, but may present witnesses regarding punitive damages. Terrible Herbst cannot dispute liability for compensatory damages, Your Honor. These items, getting back to something that Mr. Waite said, actually are tailored, and everything here is tailored to fit the ETT's extensive discovery abuses, Your Honor. And then additionally, this is the instructions, Your Honor, these I don't think have to be completely.
Can I ask you a question?
Oh, sure.
Before you get to the instructions?
Sure.
This is kind of a real water-based question, right?
Of course.
Cause of action, joint and several liability, right?
That's the conversation we had earlier today. Go right ahead, Your Honor.
Well, my question was going to be, how are you tailoring this to not impact real water?
And that's the conversation I had with Mr. Odou this morning. Your Honor, as a CD judge, quite often, well, for many years, I've had cases with Mr. Odou where I've been a subcontractor, he's been the developer's counsel, and I'm always concerned about the effects of something that the general did that may affect me as a subcontractor, and vice versa, I'm sure, for Mr. Odou. And that's why I called him at 7 o'clock this morning, Mr. Odou, and had this conversation. And that's why we come back to, I think the only thing that works for both Real Water and the plaintiffs would be a striking, because it is difficult, extremely difficult to parse out these sanctions, given the direction we have from the Nevada Supreme Court, that would not negatively affect this desk. Because they're wrong, those
Did you say
wrongs.
this desk? Well,
This
I know
desk
what
being
you're
Real
talking
Water.
about, thank you.
I'm sorry, Your Honor, for the record, Real Water, for the transgressions of ETT. Your Honor, the outrageous discovery abuses engaged by ETT, when you consider the case law we've been discussing, should not be used against Real Water. And so that's why I think even in the CCSD case, the Supreme Court thought that what was tantamount to striking the answers is what should have been done. And I think that's where we are here. This was prepared before I spoke to Mr. Odou, and I spoke to Mr. Kemp this morning, and we are struggling, because this is a very distant fallback position from striking, and it's tough, it's very tough, Your Honor.
Counsel, I'm gonna stop you for a second,
Yes, Your Honor.
because, and I looked at the answer, right, obviously multiple times, if you have a copy of it handy.
I didn't bring a copy, can you bring one up for me, Mr. Pepper?
3/21/2023 is ETT Terrible Herbst answer to plaintiff's third amended complaint, cross-claim against Affinity. Remember, it also includes a cross-claim against Affinity. And I appreciate since that time, there's been another court ruling, so and there's been a waiver or withdrawal of the negligence claim. So when I was looking at their 29 affirmative defenses
Yes, Your Honor.
and trying to determine which ones still are in play and which you're asking to strike, and
Yes.
taking into account the Blige case, which remember you have a interesting concept of how another court may view the distinction between NRCP 8C affirmative defense versus something that goes to a prima facie case, and not running afoul of that, right?
That was Justice Hardessy's whole diatribe in the CCSD case.
Well-reasoned decision, all of the appellate courts always make well-reasoned decisions.
Absolutely.
I'm a district court judge. They always make wonderfully well-reasoned decisions. Okay. Whether my name's actually on them or not, or whether or not they're my case and my name may be on it, even if I didn't make any decisions in it. But anyway, that's neither here nor there. So what we're looking at is when going through the actual answer, taking the plethora of case law that's been cited by all the parties, and which is law of the case with the court's prior order, which the court looked at this for the prior order too, I mean,
Yes, Your Honor.
obviously, is what, okay, some of these are assertions that aren't true defenses, but the court, it could be argued, okay? I'm not saying they are, I'm just saying it could be argued, but which, the 17th and 18th are punitive. You can't ask the court as a sanction when somebody's waiving it. Now, the court's not gonna do an issue with regards to the constitutionality of punitive damages and how you have to notify certain people in order to raise that. I'm not going there today, once again. That's a constitutional argument, so it can't be subject to a sanction component at this type of stage without several parties having the opportunity to be heard potentially on that issue. The unavailability of punitive, so you've got a couple punitive damages, right, 17 and 18.
Yes, Your Honor.
So which affirmative defenses are you saying are true affirmative defenses that you're asking the court to strike? And that's part of the challenge here, which is why this court walked through saying the procedural posture of this case. I kind of did the shortened version of it, right? Looking at what was still left in this case with regards to ET&T with the sole plaintiff Hunwardsen, which one of these still exist? Because realistically, the set off or offset doesn't apply to you, right? That's a real water.
That's correct.
Contribution and indemnity, and that's the 15th, 16th is contribution and indemnity. I'm not sure you'd have the standing to strike those affirmative defenses when they don't apply to you. I'm not, these aren't positions, these are just questions.
A lot of these are unfortunately not even a true affirmative defenses, and you're right.
Therein lies that's not a ruling, because that's not before the court. The court was evaluating the document titles,
Right.
answer contain what was asserted to be affirmative defenses dated 3/21/2023. And looking when you were making that request as to what actually were you requesting, because as you can appreciate, your motion didn't say strike this, and this, right? It was
That's right.
globally
The answer, exactly.
the answer, right? The
That's
affirmative defenses in the answer versus
That's right.
the answer. So then looking through these, you can appreciate the court might have had a little bit of a challenge of which ones still exist that you were seeking as a remedy that applies to plaintiff Hunwardsen, for whom this motion could only apply to because he's the only one that purchased ETT product. And that's
Sure.
undisputed because you all gave me records, and remember it was the 3.5 days with the 5 people, or, sorry, 3.5 people over 5 days doing the server.
That's correct, Your Honor. So the easy answer, Your Honor, which
Oh, good, there's an easy answer.
There's an easy answer. The easy answer was just given to me by my esteemed colleague over there, Mr. Kemp. The easy answer is you'll be striking initially all of the denials in the actual allegations of in the complaint, in their answer. So before you even get to the affirmative defenses, you'd strike all of their denials for our claims, in terms of our allegations. So that's where you would start. Remember, you don't get to the affirmative defenses until you actually respond to the allegations. So you would be striking the answer, which includes all of the denials.
Okay, court did look at that, and the reason why I'm gonna mention one is
Okay.
paragraph 49.
Okay, you go up to 49, Your Honor?
Defendant denies it manufactured real water. We know there's a lot of, that is true. We did not manufacture it.
That is true.
So
But they sold.
paragraph 50, I'm not saying, I know, but I was looking at that for denials,
Yeah,
looking through the entirety of this, and when I came upon that, and I think it's the next one too, there's a couple times, right?
that's correct.
That there are denials that are accurate denials, which all parties agree are accurate denials. I'm picking the easiest one, right?
Absolutely.
Which is manufactured. Because real water, as affirmatively stated multiple times, they're the only manufacturer. It's undisputed that Terrible Herbst is not a manufacturer, it's a retailer. That's, you all have given it, that's the way you sue them.
That's correct, Your Honor.
So I was hearing that, and that's, by the way, that statement's replete in a whole bunch of different paragraphs. I was
It is.
picking out the, like I said, I was picking out the concept, so I was looking at that as a potential remedy, but do I say, not this paragraph, but yes, this paragraph, this part of this paragraph, this part of not other paragraph? Mr. Campus, I think, about to whisper in your ear.
And so, Your Honor, I think it goes back to why Rule 37 says what it says, because if you strike the entire answer, you never have to go through any of these one by one. And I see what the court's doing. The court's analyzing what is the sum total, the result of striking the answer for purposes going forward in this case.
Which I think to do because it has a constitutional affirmative defense issue. It has at least 2 affirmative defenses that relate to real water, which you would not have standing to assert on their behalf, right? Because I can't
So then,
harm or benefit real water, right? And whereas real water might like it, I can't benefit them by your motion because I don't have a motion from them. I don't even have any joinder from them. I don't have any pleading, in fact, and then they restated in open court that they don't take a position on said motion. So I'm hearing what you're saying, but yes, I appreciate, I could could I carve this out paragraph by paragraph by paragraph? But realistically, my concern there is stir confusion.
and see, that's my point. And I think that's how I started. When I looked at what the court discussed yesterday, because it was, and to me, it was more than just an intellectual exchange between all of us. It was an intellectually challenging analysis that we had to put on last night. And so when I looked at it, I said, Rule 37 wasn't meant to require the district court to analyze the merits of the answer. Rule 37, and what we're looking at, was meant for the court to analyze the egregious nature of the discovery abuses and then apply it regardless of what kind of case. And the reason, let me say this
I'm
one
gonna let
thing.
you finish, go ahead.
The reason I say that, Your Honor, in some of the cases you got, there's a couple of cases that are really small in terms of this case, two $10,000 cases. And the striking was done and damages were awarded. In this case, like if you had an Enron case, this is a larger case. But there is no caveat or condition in Rule 37 as to the size of the case or the whether or not punitive damages were alleged as a part of the allegations. So when I looked at this, looking at the allegations here, if you strike the answer, you're not trying to determine the merits of their answer, actually responding to the allegations, or whether or not their affirmative defenses have merit either. What you're going to do, which is I think incumbent on the court based on the CCSD, we still have to put on our case as the punitives. We still have to do it. And the court still will get the opportunity after we put on our case to see if we met the requirements of a prima facie case for punitive damages. You may find, this court may find, that we did not satisfy the constitutional requirements or the Nevada constitutional requirements under NRS 42 to sustain or to validate or to warrant punitive damages. You have that ability. And the quick case law says you have that ability. So you can strike this case, this answer from ET&T and still ensure zero or whatever you decide what the punitive damage, if we met the requirements under the law of punitive damages. That's my analysis, John.
I'm hearing
But-
what you're saying, but look at the plain language of CCSD. Not all of CCSD's stated affirmative defenses were true NRCP 8C affirmative defenses. Some were merely defenses to Richardson's prima facie case. In applying the sanction order, however, the district court precluded the introduction of evidence related to all of CCSD's stated defenses, whether or not they were true affirmative defenses.
That's right.
Because the district court's application of its sanction prevented CCSD from defending against Richardson's prima facie case, we conclude that in application, the sanction was akin to a dismissal with prejudice. And it
That's
goes
right.
on to say the district court intended to strike CCSD's affirmative defenses, not to strike its answer altogether. Nevertheless, when repeatedly asked by CCSD's counsel whether the court was preventing CCSD from defending against Richardson's prima facie case, the court precluded evidence if it was related to a stated affirmative defense. The district court never analyzed, however, whether the stated affirmative defense was in fact actually an affirmative defense, because many of CCSD's stated affirmative defenses were not true NRCP 8C affirmative defenses. The court in reality applied a far greater sanction, striking CCSD's answer into paren. The
Exactly.
challenge here is what that case really tells the court, it appears, is that you have to analyze, if you say you're striking the affirmative defenses, you have to analyze each and every affirmative defense, A, to see if it's an affirmative defense or not, B, to see if you really intend to strike it, which goes to the real water issue with regards to two things, and goes to the constitutionality of the punitive damage, the two
We
punitive
agree.
damages, okay?
We
So
agree.
then if you look at the answer in its totality, that same issue exists, because then you have to look at the denials. And if you say it's stricken, so therefore they can't deny, then they can't deny certain things which are factually accurate as well as the affirmative defense issue. Therein lies the court's challenge, which is why the court gave its analysis that it did yesterday in light of the procedural posture. I wasn't going on size of the case, et cetera. I was going straight from these cases,
Right.
right? And so that's the challenge. So that being said, while this has been a wonderfully interesting intellectual conversation with each and every one of you, I have to look at the sanctions proposed by each side,
Okay.
and I think you're going to tell me
The
is
instruction.
that this addresses that issue because it narrowly articulates exactly what's being done. Is that what you're gonna tell me, counsel?
Absolutely. The instructions, Your Honor, you can read those, and I'm sure everyone has, but for the record, Terrible Herbst failed to produce more than 290 pages of relevant documents related to the relationship between Terrible Herbst and real water. It is unknown how many documents have yet to be disclosed and provided by Terrible Herbst. You shall infer that these undisclosed documents supplemented plaintiff's claims should be supported. That's wrong. Supported.
Yeah.
Plaintiff's claims and were adverse to Terrible Herbst's defenses, should be plural. You may consider this failure to produce documents in deciding whether plaintiffs have met the burden of proving that Terrible Herbst acted with fraud, oppression, or malice, express or implied, and hereby entitled to punitive, should be like punitive damages, not plaintiff
Not
damages.
plaintiff's damages.
That's correct. The last one, the second one, I'm sorry, says Terrible Herbst representation should be representatives. Provided false testimony in the form of declarations, depositions, and answers to written discovery. C, Terrible Herbst shall be responsible for and pay all fees and costs incurred by plaintiffs related to their renewed motion to strike. I think that's something that they've already agreed to, Your Honor, so I don't know if that's a big deal.
Is your
So,
net sum result for with regards to your sanction request is that whatever the jury were to award, this is a hypothetical, hypothetically, if the jury were to award compensatory damages in whatever amount it is with regards to Mr. Hunwardsen, that automatically ETT is joint and severally liable, and that you're saying it doesn't impact real water because there would have been an affirmative determination they would have participated in the litigation? Is that what you're saying?
That is correct. I think that's where there is and that's what I spoke to Mr. Odou about. And so, Your Honor, again, I was trying to avoid, and without me going over it again, trying to avoid the effect of real water based upon what I consider to be outrageous discovery abuses by ATT. And that's why I keep coming back, giving the rule that the only way to do it, and allow the court to decide a prima facie case being met, which is consistent with CCSD, is striking the answer. And I still understand the court's position.
Okay, I think in fairness, ETT, I'm giving you 5 minutes if you want to say any summary of anything, because some of these issues came up after you had a chance to speak. If you don't, you're not required to. And I can appreciate you usually giving the lawyer a chance to speak, they're going to speak, so go ahead if you want to.
What I would really appreciate, Your Honor, looking at the clock, if we could take the morning break, so I could consult with people. Obviously, we're seeing this, and there's many people that are in the mix. If we could use that morning break to consult and then come back and give you our brief response.
Jury's all present.
Yes, Your Honor.
There's a little sign, thank you, yes. Well, before you do that, I have to ask this question. Is ETT gonna request, I have jury written in the hall, that I address your rehearing on your motion for summary judgment? I get this.
Your Honor, we would like to address it, but are not objecting to push it back to whatever is going to be.
I'm just trying to balance where you are with regards to, I mean, I'm fully appreciative that opening statements are going to address the scope, but I'm also appreciative that this request for sanctions, right, pretty much subsumes the concept of the motion, does it not?
Could I send a text real quick to Mr. Smith? There might be a resolution here.
Yes, sure. You know what, short answer, I'm going to give you all a 10-minute break. Okay. Let's get this taken care of. Marcia, can you tell our jurors, counsel for ETT, did you want your few moments?
Yes, thank you, Your Honor.
Okay, please.
Addressing the motion for rehearing, I've talked to Mr. Parker. We are both agreeable to submit it on the briefs. We'd like a ruling before the opening statements. We suspect, although you may tell us differently, we suspect you're probably ready to rule on it. And that will save everyone some time. As it relates to the proposal, I guess my response is we don't have a formal response to the proposal simply because the way that the motion was styled and argued and so forth, they're now shifting the focus, the linkage, if you will, from the harm to the prejudice. This all focuses on the compensatory damages, and that wasn't how their motion was framed. So we don't have a response other than the Nevada law clearly requires that there be a causal link or a linkage between that the punishment is related to the harm.
Okay. So, let's address each of these. Here's what the court is going to do. With regards to the motion to strike, the motion to strike was to strike the entirety of the answer, which would include all of the affirmative defenses. And those affirmative defenses include affirmative defenses related to punitive damages, as well as compensatory damages, as well as several other aspects. The court had already stated yesterday that it did not find that that would be the appropriate remedy because for the many reasons stated both yesterday, day before yesterday, and today is within the standards of the case law, with closest looking at all the cases, including, like I said, the December 2023 case, Blige that you all mentioned, is that would not be the appropriate remedy given the procedural and factual aspect of this case for the reasons stated and clarified today in some regards. So what the court then said, it was going to look at lesser sanctions, gave the parties each an opportunity without counsel for ET&T waiving the right to say that there should be no sanctions or there should be something really minimal to see if the party is going to provide an opportunity. In looking at all of those, I have to look at that some of the lesser sanctions requested by ET&T are already contained in the court's prior order, and so that doesn't go to the severe nature. Now, to the extent that there may be an issue with regards to the court's willfulness analysis, this is so close to willfulness that I have to do it, since I did not find express willfulness, is why this, and you don't actually have to find express willfulness to strike under MDB trucking, but even if that were viewed, that's why the court is doing lesser sanctions, but it is so very, very close for all the reasons stated, like I said, on the record and incorporating the pleadings from plaintiff as far as their analysis on their reasoning for the motion. So then the court has to look, what's the appropriate lesser sanctions? The court really finds that in looking at the answer, because the issue of real water being a party to this case, and the court can't advantage or disadvantage real water, realistically striking the answer of in its entirety and also the issue with punitive damage, that's not the reason. That would not be appropriate. So the lesser sanction is going to be what's requested by plaintiff as their far, far, far second choice with a modification, okay? And there's okay, so let me read. So I'm going to adopt A, Terrible Herbst is going to be precluded from any arguments or evidence regarding compensatory damages at trial. This includes but is not limited to 1, Terrible Herbst is prohibited from offering arguments or references regarding compensatory damages during opening and closing statements. So it's opening statement, closing argument, including but not limited to the nature, extent of plaintiff's injuries or damages, either in category or amount. Terrible Herbst is not precluded from arguing against liability for punitive damages and is also not precluded from arguing against any amount of punitive damages. Okay, so not only for liability but also amount, that this does not merit punitive damages. This is purely a compensatory damage sanction. And I'm going to give the analysis, more analysis in a moment. 2, Terrible Herbst cannot question any of the compensatory damage witnesses unless said witnesses are also going to be utilized for purposes of saying that punitive damages should be asserted. Okay, and so if they're going into that aspect, then yes, Terrible Herbst can. But if it's a pure compensatory damage, experts say, for example, I'm about to get to those, including but not limited to Myles Hunwardsen, I'm going to have to leave and defer on Myles Hunwardsen because it's going to depend on how questions are asked. If they go into the area of potentially the availability of punitive damages, the need for punitive damages, or an amount of punitive damages, so I need to reserve that. I'm only talking the first prong of the trial. If the trial does get bifurcated, there is a punitive damage phase, the sanctions not for that second stage, okay? With regards to the medical professionals, then they are precluded. And those medical professionals, I need a point just of clarification, because one of these is an economic, and you just got to refresh the court's recollection. Counsel, of your listing in subpart 2.
I thought it was Mr. Rich. Yes, Mr. Rich is not on the list, Your Honor. That's the one you're speaking of.
Okay, so then it would include Dr. Hudson, Steve Uhas, Dr. Alcina, Matt Sims, and or Melissa Keddington, or somebody that is brought forth. I'm not sure if someone's going to get ill, hopefully they don't, but somebody who you brought forth to provide a compensatory medical component. With regards to if any of those witnesses go into the area that could be for punitive damages, you need outside the presence of the jury, let the court know if Terrible Herbst is requesting to do a cross-examination of said witness, okay? So I'll have to hear what plaintiff's direct is first in order to know. Terrible Herbst cannot present its own witnesses regarding compensatory damages. That's the cleaner one because those would be pure compensatory damages. To the extent that he's told this court that there was a witness for compensatory damages that somehow is going to overlap into punitive damages. But if Terrible Herbst is saying one of their designated compensatory damage witnesses overlaps into punitive damages, they're going to have to let this court know outside the presence of the jury. The court ought to make a distinct evaluation of that individual or individuals. Terrible Herbst may present witnesses regarding punitive damages. Terrible Herbst cannot dispute liability for compensatory damages. Now, that is realistically the current status of the case pursuant to the summary judgment as far as liability. With regards to the ruling, the court will address that in a moment. With regards to the jury instruction request, with regards to the jury instruction requested, the court finds it's more appropriate to address those jury instructions, since they can't be brought up anyway in opening statement, to address those at a time during the trial so that everyone has a full and fair opportunity to see where the evidence is, and B, what would be an appropriate jury instruction. The court is inclined to give a jury instruction that does address the issues presented, including the failure to produce the 290 pages. But realistically, you all look through some documents, and as far as the relevant aspect of them at this juncture, we've highlighted certain documents to the court. The court doesn't know of all 290 pages. I don't know if one just has a big, huge smiley face on it. Actually, I do, because you all gave them to me and I've looked at them. But as far as the relevancy, realistically, that means the jury instruction has to be deferred to a time, and you all will pick a time during the trial for the court to address the jury instruction request. And that goes to both B1 and B2. With regards to C, Terrible Herbst shall be responsible to pay for other fees and costs, including plaintiffs related to the renewed motion to strike Terrible Herbst's answer, subject to the court's review and consideration of Bunzel factors. The court's going to find that that is appropriate because this motion was only necessitated by the actions of UTT. If they had done it in a timely manner, then this would not be necessary. The court would not find that that is overly burdensome. Now, when the court looked at the fact with regards to these remedies as sanction, the court also has to look at some of the proposals of what really would have been the cost of doing a whole new trial and how that would have been assessed to ETT. Realistically, the compensatory damages of Myles Hunwardsen, I'm not saying that you all could probably, maybe less, or maybe significantly less. But realistically, the court does find this is an appropriate remedy. The court does find a nexus because the whole aspect with this case is the issue has been raised over and over that Mr. Hunwardsen drank the big jugs. And only got ill after he drank the big jugs versus the small bottles. And that whether or not Mr. Hunwardsen did or did not see certain things on gas pumps because they didn't exist, is what was referenced to this court earlier during the time frame in which he drank the Terrible Herbst based on the subsequently produced documents, not an issue for this, that the documents that showed when he did do the actual purchases of Terrible Herbst. So the court does find it directly relates to the compensatory damages and for all the other reasons stated in brief. And the court also, like I stated before, does have to take into account that it's not striking punitive damages, so it's a lesser sanction. It's not impacting real water, because this can be phrased specifically as to Myles Hunwardsen in the plaintiff's opening. It can be phrased with regards to the witnesses, that this examination goes to some of the potential witnesses. And realistically, the jury shouldn't have any confusion because the lack of asking questions about a particular person's injuries has happened all the time. There's lots of times been on verdict forms where there's been, quote, even take a standard car accident case. Sometimes there's a stipulation of X amount of damages, but maybe there's a dispute as to the need for a future surgery. So that is, we don't have a jury confusion issue. This is a clean, clear issue that meets the sanction component, takes into account all the case law that's been cited, takes into account all of the statutory provisions, fair and equitable, and does not impact real water to any extent that this court's been notified of. And so therefore, that is going to be the remedy. That means you put on your to-do list as far as the jury instruction, how that gets addressed. And at this juncture, the court is so ordered as the court's ruling. And remember what these rulings I'm making during trial. So far, this court's understanding is that you are, as it would be with any trial, oral pronouncements from the bench during trial are effective for purposes for trials. Anyone requiring that this court stop this trial at this juncture so that you do a written memorialization of said order.
Now on behalf of the plaintiff, Joul.
No, I'm after real water, Joel, with it.
Your Honor, on behalf of ETT, we're fine with that as well. I do want to just point of, not clarification, but my appellate partner wants to make sure that it's on the record that we are reserving rights under Paul versus Cook.
Oh, you didn't cite it, I said it at the beginning, before you said a single word, I've restated it, the court's not taking any position on anybody's appeal right. But, okay, I can't, I don't, I'm a district court judge. But, that being said, okay, that takes care of that issue. Is there any other issues, such as, has the demonstrative exhibit issue been resolved, or is there anything that's precluding the jury from coming in, giving its general instructions, and then commencing with opening statements?
Your Honor, could you simply give, since we're submitting the motion, the renewed motion for summary judgment or rehearing?
Oh, you want the ruling on that?
Yes, Your Honor.
Okay, based on the agreement of the parties that the court give a, submitted on the briefs, you can appreciate that this doesn't really necessarily come as a surprise to this court, and plus you can appreciate I was prepared anyway, last several days to do it. So the court has to take the motion for rehearing for a couple of different bases. One, I have to take the timing. Mr. Love, did you need to be heard right now, or can I make my ruling? No, you're welcome to stand up if you're standing up to stretch. Is there an immediate issue for right now?
No, Your Honor, we're just gonna raise a little housekeeping issue on the demonstratives before we open, but that's after
Okay,
the
no
matter
worries.
is discussed.
Okay, so, sorry? Okay, so what the court is looking at is, I don't total all the various documents, give me 1 second to pull that document out. Okay. So, motion for rehearing and or clarification of oral ruling on plaintiff's motion for summary judgment as to 1, plaintiff's claim for strict product liability against Real Water and Terrible Herbst, and 2, that Real Water and Terrible Herbst sold an adulterated product, document 1146 filed on 1/12/2024, OST document file 1193, NEO 1196, plaintiff's opposition thereto 1215. And reply thereto, document 1221. So, in the court, in looking at that, as you know, really the court has to look at it for a couple of different things. First off, as of the time of this, the court has memorialized its order in writing, did have an opportunity to review both of the competing orders that were submitted to the court signed and edited the appropriate order that it found was appropriate. So right now, it's not an oral ruling, so I don't have the Division of Family Services and Rust versus Clark County issue. You have a memorialized written ruling, and the court's really addressing it from that memorialized written ruling. So they're really looking at it as a rehearing or clarification with regards to that ruling. When the court looks at that, you know, it's a couple pronged standard, even though you've titled this as a rehearing or clarification, the court really has to look at it as a motion for reconsideration standard, because realistically, it's asking the court to review its prior order. Look at the motion for reconsideration, you've got the two-pronged analysis. First, you have to see, is there something new or different, or is there an issue of law that the court has addressed incorrectly. So when I do each of those, I look at the aspect. I do not find, there's no new law that's come about. There's, with regards to new facts, here's what the court's doing. To the benefit of ETT, I'm not taking into account any new facts that have come across with regards to documents and the document issues that the court just addressed in the evidentiary hearing. So to the extent that there's issues raised about maybe other documents out there, are the things that doing it, I think it's to the advantage of ETT, but I'm not saying that there is anything negative, no negative inferences with regards to that. I'm only looking at the straight pleadings. When I look at the straight pleadings, it doesn't meet the first standard with regards to a motion for reconsideration. So then we look at the fact of, I'm still going to give the analysis, even though I don't think it meets the first prong. I'm still going to say, even if the court were to view that there is an issue that the court should look at it substantively, the following analysis is, the court does not find that it erred in accepting real water stipulation and overlooking ETT's evidence, calling the plaintiff's causation theory into doubt. Realistically, I had what the court had. The stipulation only made certain statements. The court had to take the stipulation into account only really in the limited context that the court did. The court did fully evaluate what ET&T's position is. So here, I did look at your Dr. Stelplug, and I'm going to mispronounce it, STELLPFLUG, with regards to the concept of whether or not things contain understatement. That was really part of the court's ruling, okay? The court already addressed that. And I addressed that with the competing issues that were presented. So that really is not a new issue of law or fact. It's really second bite of an apple. But even so, the court still looked at it, and the court did look at all of the aspects that were presented. Now then, we talk about tying into the tobacco litigation aspect that was brought forth in the brief. When the court looks at that, the court really sees that it is distinguishable. The court doesn't find the length of harm, et cetera. That's not really the necessary of exposure, because here you already have uncontested facts, and you don't have anything from Nevada Beverage, right? It really says that there was anything done or changed or harmed. What you just have is you have speculative aspect really from ET&T as to what they got. And they did not get it directly from real water. They went to manufacturer, as they pointed out multiple times, and denied, like I said, multiple times in their answer. So when you look at the context of everything, that the court doesn't find that the court should revisit it. When the court looks at the same arguments that were presented, the same analysis is the same thing that the court said previously, as memorialized in the written order in a more articulate manner than necessarily it always hears directly from the bench. And the court is cognizant with regards to the remedies, with regards to a motion for reconsideration. I'm appreciative that there's an argument with regards to the distinguishability of the various cases cited. The court considered the applicable case law for the issues at hand. So the court does find that the court's order granting partial summary judgment was clear and correct. Realistically, no one was contesting that I did the wrong legal standard. You just disagreed on which of the facts that the court applied. So And I looked at what ETT agreed with and disagreed with. ETT with this aspect of with regards to E2 concentrate and what the FDA did and did not find really was undisputed. What really there was a challenge is how the court should review and view Dr. Hudson's testimony as far as some of the other individuals' testimony to see whether it was such a dispute that raised a material issue of fact. And the court really finds that it doesn't. So therefore, the court finds both procedurally, it's not a proper motion for reconsideration. Substantively, the court would reaffirm its prior order. It does reaffirm its prior order as memorialized in writing, and the NEO was filed therein. And once again, the court is taking this as, there were some procedural issues raised as well, that this is an improper motion. It is an improper motion because you can't file a motion on a court's oral ruling. There is no citation to any way how you can. So, but the court, however, despite the fact that it's an improper motion, because there has not been the, at the time of the filing, there has not been the written order which triggers a reconsideration. You can't just label it something different and then substantively to reconsideration. The court, that would be an independent reason, but the court still did standard analysis with regards to a motion for reconsideration and fully looked at the substance as well, so gave that three-pronged aspect. Separate and apart and independent, which was not at the time of the court's initial review, but based on the court's ruling of a few moments ago, with regards to the sanction component, that would provide an independent basis. The court's not saying that's for basis of the motion for rehearing, and so realize that these are all independent bases, right? The procedural improperness at the time of filing it with regards to an oral ruling. In fact, it doesn't mean a motion for reconsideration, substantive, and a fourth independent basis is the sanction component that was just addressed, okay? It is so ordered, that's the court's ruling. Does anyone have any questions, counsel for plaintiff?
No questions from Plaintiff, Your Honor.
Councilor Water, do you have a position on this?
No position, Your Honor.
Councilor ETT, do you have any questions?
Your Honor, it's Mr. Smith's motion, and I see him tuned in. He might want to say something.
Yeah, I just did want to clarify your first point on the timing of the motion. Obviously, when we submitted the motion, you were correct, there was not yet a written ruling. I'd be happy to go through the exercise now that there is a written ruling of filing a formal motion for reconsideration of the written order. But given the rest of your analysis, I don't necessarily think I don't want to waste everybody's time in doing that. Would it be okay if I got everybody's agreement that we would agree that despite what you're pointing out as a procedural problem with having
Rust versus Clark County and Division of Family Services, it's straight case law, but yeah, go ahead. So what you're asking is, will the parties agree that this was just treated as if it was a proper motion, even though there has not been a written order at the time it was filed? Is that your question, Mr. Smith?
Yes, Your Honor.
The court takes no position. I ruled on it, the 4 different independence bases that I ruled on it. So I take no position, but since you've made that request of each of the council, I will ask the council what their position is. You heard Mr. Smith's request. Council for plaintiffs, would you like to respond?
Your Honor, we would just like to stick with the court's ruling. I think
Thank
the court analyzes both procedurally and substantively.
Council for Real Water, do you wish to state a position?
We have no position, Your Honor.
Okay. Well, since the request came from ETT, do you want me to ask you whether you have a position of your co-counsel's request?
That's not necessary, Your
Okay,
Honor.
no worries. So, Mr. Smith, that's the answer you received. Like I said, the court takes no position. The court did fully analyze it as if it had been proper, but like I said, that's why you got 4 independent bases rather than them being subsumed. Now, of course, those 4 independent bases from this court's position stand independently, but also if you put them in any combination of any 2, any 3, or all 4, then they also would be doing it, but they do stand independently as well, okay? Anything else?
Thank you.
Sorry, Mr. Smith, I didn't want to cut you off. My apologies. Was there anything else?
No, Your Honor, I think plaintiff's comments, at least as I interpret them, would mean that because they're standing on that first prong, we would need to file a subsequent 2.24 motion, even just to go through that exercise. Apologize, Your Honor.
Court takes no position. The court's not making any determination or ruling. You just are remotely, and since you asked the question, I put it out to the parties if they wanted to answer it. Okay, you understand it's nothing from the court, right?
Your Honor.
I appreciate it. Thank you so very much. Okay, that took care of that ruling. Is there anything, I think, Mr. Love, you were about to say something with regards to demonstrative.
Yes,
Is
Your
there
Honor, Mark
any
Love,
outstanding issue with regards, I'm gonna focus first just on plaintiffs because in order to see if I got some time as far as the lunch break issue, if it's any of the defendant parties, right? Because plaintiffs are gonna take any lunch hour since it's already 11:10. How long's your opening?
Your
I think it's gonna go about an hour and a half, so I can either. try to
Both
do
of
that.
yours or just yours? Are you, how long's yours? Mr. Parker, you doing one as well?
I am, but mine's gonna be shorter. I'll be less than an hour.
2.5 hours, okay. Sorry, Mr. Love, go ahead, please.
Sure, I was just gonna comment, we have a PowerPoint for our opening for real water. Mr. Kemp said he had no objections to any of our slides. I haven't heard back from Mr. Parker one way or the other. I'm assuming he has no objections because he hasn't indicated any, but I just wanted to make sure before we start on our opening that that's the case. And then likewise with Mr. Parker's slides, I understand that Terrible Herbst has a couple of objections, and likewise Real Water has a couple of objections at some of those slides. And so we would ask that we resolve those prior to Mr. Parker's opening, but we have no objections to anything in Mr. Kemp's.
Okay, so what makes the most sense, the council requesting of the, oh, sorry, Mr. Boho, I didn't see you starting to stand up, I saw that.
It seems to me that the suggestion might be then consistent with what Mr. Love just said, is that we don't have an objection to the exhibits within the opening by Mr. Kemp. So that takes us past lunch, regardless of whether we do it, whether he starts before or after lunch. And then at the lunch break, whatever that is, we can address anything with regard to Mr. Parker.
Okay, well, it sounds like Real Water and ETT are on the same page, plaintiffs, are you on that page or a different page?
No, that sounds great, Your Honor.
Okay, so then the next question becomes, I mean, you all know your jury's been waiting out there. Do you want me to, do you want them to come in
I'd
as?
start, and if you want to stop at lunch, I'll stop at lunch.
I'm gonna ask you because I really leave it up to the councils.
I don't think it matters, Your Honor.
Okay.
I mean, when I was a younger attorney, I thought it mattered, but I don't think it matters.
Okay, then what we're gonna do is ask the marshal to bring in our panelists. Remember, I've got about 10 minutes of introductory aspects I have to explain to them with regards to, you know, the various notepads and various other things, okay? So, and then you can start, and realistically, as long as I give 12:15 is gonna be a ballpark, Mr. Kemp, for a good time around.
12:15, and tell me when you want me to.
I'm gonna let you decide when there's a good stopping point, but I'm gonna say around the 12:15 hour, okay?
All right.
So you can tell what's appropriate. Thank you. Okay, thank you, Marshall. Yes, please. Oh, sorry. Okay. And remember, you do have individuals who are watching via Blue Jeans. This is now obviously the public courtroom part of it, and we don't have no idea who's watching or not watching. We leave that each and every one of you, that you don't have any witnesses, right, either this case or, because we have the exclusionary rule, and so we need you all, because you know who the witnesses are, to take that wedding, or at least periodically either peek back here, or if you want us to pop up Blue Jeans.
Pop it up right now.
We can pop it up right now if you want to. But presumably you all said that you were gonna let each of your respective witnesses know that they cannot appear. So, does anyone see any issue with any of the people that are currently on the screens? If you need to stand up or get closer, feel free to do so. But it should be on your monitors also. Should we chance check the back?
They turn themselves off, so you have to read.
Right.
Just do it fast.
Yeah, sure.
Within 1 to 2 minutes.
Are you okay if the jury's on their way in, he's already lined it up and coming up the hallway, do you want me to stop him? Or do you want
No, I'll just come right in.
Yeah, that's fine,
quietly
I'm gonna go going through all my preliminary stuff, of course.
Gotta be careful with that food down here.
Okay, folks, ready if the jury's coming in?
Yes, thank you.